Members, once again, so just here from the DACASA office, and today we've got a nice special meeting for you, or discussion, and we're going to talk about the infamous Protection of Personal Information Act, also known as the POPI Act. So luckily, you don't have to hear just from me today. We've got a specialist in-house. We've got a meeting with her. Her name is Judy Knutzer. She's a long-standing attorney as well as debt counsellor and DACASA member. So she specializes in the Protection of Personal Information Act and the compliance. And we've got her in studio today to have a few questions, a Q&A. Hi, Judy. How are you doing?
Hi, Vanessa. Fine, thanks. And you?
Good, thanks, Judy. Are you ready for the questions? Thank you so much for your time, by the way.
Thanks.
So let's just start. I'm going to ask you quickly, what is the purpose of the POPI Act?
The Act gives effect to the constitutional rights to privacy by safeguarding personal information of any individual or juristic person when processed by a responsible party. You as the data subject, me and you are data subjects when somebody else processes our information, we have a right to privacy of our information. But we as debt counsellors have a right to protect. We are the responsible party, so we have a duty to protect the information that we process from our clients.
There's a burden on us, so that is our.
Yes.
We have to make sure that we protect our clients, and especially with debt counsellors using so much personal information. So this is very important for our debt counsellors to take note of, to implement and to comply. So now quickly tell me, who has to comply?
It's very important to understand that absolutely every law company that processes any information of any kind has to comply. Even if you have one employee and you process his ID and his employee contract, then you are processing personal information. So we as debt counsellors, like you said, we process a lot of personal information. We process names, marital status, financial status, banking details. So we have a very big duty on us to comply with POPI.
This is very important. Now tell me quickly, I think most of my debt counsellors wants to know, what is the first step to take to ensure compliance?
The first step you have to take is to register an information officer. Now the information officer is usually the CEO, the MD, or the owner of the company. If you've got a large company and you can't deal with everything by yourself, you can register yourself as the information officer. You have to be the officer because you are responsible for the protection of the information. You cannot appoint, say for instance, the cleaning lady or somebody who just works in the office, because you are the responsible person. You can also appoint a deputy information officer to assist you if you have a large company and a large amount of information that needs to be processed and protected.
To assist with that steps. But it should be somebody that's competent enough and to know what they are doing.
Yes.
Okay. So besides the first step, what do we do next after we've appointed an information officer?
The next thing you have to do is you have to compile a POPI manual. In that manual, you have to set out the purpose of your company, the purpose of, and that purpose tells people why you are processing their personal information, what you're going to do with it, why are you going to use it, and who are you going to give it to. You have to add all of your third parties in that manual, as well as the operators that you're going to use. And in our case, like as debt counsellors, the operator is the PDAs, and the operator is also the software that we use. So for instance, I am with the IPDA and I use Maximus. So both of them are operators, and both of them also have to comply. They have to, I've already received letters from them stating that they are on their side POPI compliant, because it doesn't help that I'm compliant and I share the information with a third party that's not compliant.
Absolutely correct. You need to make sure that you comply and your third parties comply.
Yes.
That's wonderful. So now, my service providers are complying, we are complying. Now, how do I indicate to my clients that I am compliant?
Every time a client fills out an application form, you have to have a clause in the application form stating that you are compliant, and also that they give you explicit consent that you can process their personal information and hand it to third parties, all in accordance to the purpose of your company. Only in accordance to the purpose of your company. And you always have to have a manual readily available. You don't have to give a manual to each and every client, but each and every client has to sign a consent, and that consent also has to state that you are compliant. Also, at the bottom of your emails, you have to state that you are compliant. Everybody has to see somewhere that you are compliant, and you have to have all of that information readily available. You can upload your manual onto your website. You can for anybody so that anybody can see it there. You can have hard copies in your office for anybody, for easy access for anybody to see it. But it has to be readily available, and it has to contain all of the information needed for everybody to understand why you are processing the information, what are you going to do with it, how are you going to safeguard it. All of your measures have to be included in that manual.
I think you mentioned previously that you can actually link that. So you upload it to your website and you link it to your email, so it's there for easy access. Just to make sure that you can see it easily, or the third parties. So that is, and the clients, as you said, application form, I just want to clarify the form 16 of the debt counselling documents. Thank you for that, Judy. So now many of my members also ask, what measures do I have to put in place in my office? So the actual practical measures in the office, what needs to be done?
In the office, you have to make sure that all of your hard copies of the files are locked away. You cannot have it lying around. You cannot take your files with you to town and leave it in your car. If that happens and something happens to the file, you have to report the breach, because that is a breach of the person's privacy. You have to report it to the person whose file is missing. You also have to report it to the regulator, and the regulator will then have to see how much damage was done, and according to that, damage measures will be taken to deal with the situation. So you have to be very, very careful that all of the files are in a cabinet at all times when you are not using them. You cannot have 3 people's files lying on your desk while consulting with another client, because they can easily have a look at the information, and then there is also a breach. So you have to have it locked away in filing cabinets, safely in a cupboard, somewhere safe.
And with regards to PC, if you're working on the PC and you leave your table, then put your computer to sleep. Make sure there's a password so nobody can just enter your PC.
Yes,
that's correct.
Yes.
Okay. So just make sure nobody can see the consumer's any personal information. So what about the advertising or marketing materials? What happens in that regard?
You have to have explicit consent from somebody to send them advertising and marketing materials. There is not supposed to be any more of those SMSs that they send you that says you can opt out if you don't want to receive this SMS, because nobody is supposed to have your personal information or to send you advertisements or marketing material or anything if you haven't explicitly consented to them sending you the material. So that is the case with companies that sell personal information to other companies to use for leads of any kind. You are not allowed to do that, because those people have not consented to you using the information and selling it to somebody else.
As we spoke previously, we have to be aware of these companies selling leads now to debt counselors, yes, because not just those companies was
contributing, they are definitely not compliant.
And you will also not be compliant if you
yes.
Okay, so what will happen if my company is not compliant with the POPI Act within the time limit given to us?
Well, the regulator is definitely going to send out agents to do investigations to see whether people are compliant, and also if a breach is reported and they find that you're not compliant, you can be fined for an amount of up to 10 million rand, and they can also be possible jail time. So it depends on the breach If it's only one person's information and they were not really negatively affected by the loss of it, it will be obviously a smaller fine. But if it's a group of people and you don't know what the adverse effects could be to them, then it could be a larger fine. So it's definitely not worth it not to be compliant.
Okay, and tell me something. This is quite a serious thing. 10 million rand is not, we're not playing around with 10 million.
No.
So my debt counselors should really ensure that they are compliant. And if they are battling with anything, you are a specialist. You also offer your services to assist with drafting the manuals. I mean, you are a debt counselor as well. So if they need any assistance, further legal assistance, they can contact you.
Yes.
Okay, so I'll link your details down in the description of the video wherever we post it. Another thing is, and I've received this question quite a lot from my debt counselors, do they have to send to the third parties encrypted emails?
No. If you have your client sign the Form 16, and in that Form 16 they give you consent to use their personal information for the purposes of your company, then you do not have to send encrypted emails because you have their consent to send it. Most of the creditors have their own measures in place, so they send encrypted emails because they don't have the official consent of that person to send out their information. So they have to be compliant from their side. And big companies have a whole lot of different sets of rules for them to be compliant than we do.
So with us, if we indicate this is the service providers, only these entities will receive your identity, your personal information, then we don't have to encrypt because it will only be in terms of the application form.
And in the manual, we state that your third parties are your creditors, the tribunal, a court, the PDA,
NCR, everybody.
So all of those people can receive your information because you have consented to that.
You've consented. So Judy, you just made everything simple. You simplified everything. It doesn't need to be such a huge different or a burden if you just draft your manual, report your information officer, and ensure you lock up your computer and you lock up your files. So it's not such a big thing to implement. Just do what you need to do.
Yes, it's not a very daunting task. You can just have a very simple questionnaire form that I send all of my clients who wants to become POPI compliant. And if they fill in that form, I can, based on that information, I can draft their manual. If they have a manual in place and all of their documents or have the clauses and they have all of their measures in place and everything is set out as it should be, then they would be completely compliant. It's not very difficult for a debt counselor to become compliant. We can help them very quickly.
That's wonderful news to hear. So you've got any last tips for the debt counselors out there?
Well, the deadline is looming. It's on the 30th of June. So the sooner you become compliant, the better. Just look at your operation, see where you can make changes. Ask me if you have any questions. All of us already have certain measures in place. We already have the filing cabinets, the files in a certain place. So we're already one step ahead of some other people who have nothing in place. Just make a point of it to do it today as soon as possible because it's already the 24th and the deadline is on the 30th.
That's correct. Well, Judy, I truly appreciate your time. I mean, this helped quite a lot, and I truly hope that my members will listen to this and also feel a bit more comforted that it's not a daunting task. And hopefully we'll do another video later on, maybe how the practical implications are, a video on that.
Yes.
See how it goes. I truly appreciate it. I'll link all your details as well. So have a good day further.
Thank you, Vanessa. Bye-bye.
Bye.